I would like to be able to say to you that, look, here's a copy of the statute, you can read it over, but it doesn't work that way. I think it was done just purposely to confuse attorneys, just make it more difficult, because the statutes are spread out over a wide variety of titles in the U.S. Code. So the Anti-Terrorism and Effective Death Penalty Act is not just like Title 18. I mean, it's all over the place. You have different sections and different titles, so it makes it difficult to track down any kind of comprehensive uniform look at the law. You really have to look at all of them and kind of cross-reference them. This is the first you're going to be looking for. The Act provides for expeditious removal proceedings, meaning that they want to get you out of here as quickly as possible. There is no right to bail, and this is really kind of consistent with the Eighth Amendment bail rights, where typically if you have a right to bail at all in a criminal context federally, it just has bail has to be a reasonable amount if you have a right to bail at all. Here there is no right to bail, so people who are going to be subject to this are held without bail in detention until such time as they've been removed from the United States. There is a worse than having the bail is that's not the worst thing. The worst thing, there's mandatory detention during the pendency of the removal proceedings. And by the way, you got to tell your clients, if you're representing people who have these types of issues, these are all the things you're looking at under these two statutes, assuming that your client's not already in jail and being held in high bail. Individuals who have been so kicked out of the country are permanently barred from readmission into the United States. And when I say readmission, this means that someone he's out of the country or she's out of the country but wants to come back in on some basis and be readmitted. So when we talk about readmission, we're talking about people outside of the country who want to try to come back in. They are barred forever from coming back into the United States. There is no mechanism for judicial review of the immigration determination here. You know, Congress has the authority to set the jurisdiction of the federal courts, and one of the things they did is to divest federal courts from hearing these types of cases. The only way you could really get into federal court on one of these is through a habeas corpus. But other than that, there is no mechanism to get into federal district court to challenge these things. The statute, this really doesn't have that much impact now, but it does apply to retroactively to aggravated felonies, but that would be pre-1996 matters, not of too much significance for us here today. As you note here, it can apply to almost any drug offense, even New Jersey DP possession of marijuana in excess of 30 grams. So you'll see when we talk about these removal statutes and what constitutes an aggravated felony, one of the things you've got to be very sensitive to if you're doing a DP possession of marijuana is to try to get some way of getting it under 30 grams, which will take you outside of the ambit of being kicked out of the country. We'll talk about some of the mechanisms you may want to utilize to do that. Generally speaking, the punishment that people are going to receive under this is far greater for the non-citizen than it would be for somebody who is a United States citizen to whom none of this would apply. Now, there's an additional statute over and above the anti-terrorism and the illegal immigration reform, and that's set forth in this section of Title 8 of the U.S. Code. And it relates to the inadmissibility of aliens who are convicted of certain criminal conduct. So people who would do crimes that are not necessarily aggravated felonies, getting kicked out of the country and being ineligible to come back into the United States. All right? So we'll talk about that. We'll also talk about how that constitutes an independent ground for removal. You've got to be aware of that, so if your client's charged with those things, you can take the appropriate action. All right? Okay. Now, in terms of structure, and this is really more for defense counsel than anybody else, I want you to think about the materials we're going to be doing tonight from two perspectives. One being pre-conviction. In other words, the client's been charged as a criminal offense pending or an indictment pending, and what steps you should be taking. And the other one is post-conviction. Your client's he's already pled out, he's been sentenced, and now he's got some type of removal proceeding, or the removal proceeding's already happened, he's already been kicked out of the country, and wants to try to get back in, okay? These are two distinct areas where you have to kind of move forward and know what you're talking about, and understand that, there's different strategies, different approaches that you have to take to them. Now, what I'd like to do is talk first of all about pre-conviction. Arturo, come on up here. All right. I want to give you a hypothetical situation. Let's say that you have someone who has come to you to be represented in a criminal case. The guy's out on bail, all right? but he's facing something that could nominally be construed to be either an aggravated felony or a crime of involving moral turpitude. Okay, what strategy do you take pre-trial in order to kind of massage this to get him out of the ambit where he's going to get kicked out of the country?
Well, nowadays, frequently, that person has already seen, if he's out on bail, he's already seen his friendly deportation officer. Because nowadays, when an alien, especially an alien who is not a permanent resident, when an alien is arrested by the authorities for any indictable offense or even for a DWI or anything, they contact local law enforcement contacts immigration. Immigration makes an initial determination as to whether this person should be permitted to leave on some sort of bail or bond. And for that reason, usually when it's a very serious offense, there is for example, an aggravated assault or attempted murder or something really drug trafficking,
sex
assault. Usually that person, if he talks to an immigration attorney before posting bail on the state charges, the immigration attorney will say, if you go to immigration court facing these charges, you're probably going to be deported. You're not going to get any relief from the court. So why don't you better solve your problem with the state court? And then we see, unless you want to be, perhaps you want to have this order of deportation, perhaps it helps on some plea bargaining fashion. Talk to your criminal defense attorney about that, see if that would help him. But if they're out on bail from the state and also from immigration, once in a while one of them gets away from immigration before they set bail, they come to me. Then the considerations are, is there any crime that is a crime not involving moral turpitude that he could conceivably plead to, and is it somebody who is not a career criminal and who has some options of entering into PTI or some diversionary process, some way to resolve his immigration problem. If he's a career criminal, has many convictions, many problems, probably he will not be able to stay, or she will not be able to stay here, and so he needs a criminal defense lawyer to try to resolve that problem. But for example, I had recently a gentleman who was convicted of who had an eluding charge, giving false information to a police officer, assault by auto, and DWI in Union County.
Right.
And what I did is I looked at all these statutes, and I decided that assault by auto did not required essentially negligence as mens rea.
The giving false information probably would get him kicked out of the country.
That's right. And assault by auto, it was perfectly. So what happened is they arrested him. He was in custody. He pled to the assault by auto. He was given 1 year probation, and immigration saw him immediately. They gave him a $7,500 bail, and he came out. And now he's out. He's trying to figure out what we're going to do. Actually, we just went to court today, and we're going to go back on December 8th to figure out if he's going to apply for asylum or some such other thing. But for him, it's very important that he's out.
See, the spread, this is how important this stuff is. With the spread of charges pre-trial, that's really a textbook case where you have somebody who has eluding, assault by auto, and giving the cops false information.
Yeah.
The giving the cops false information is actually that's the charge that they're going to throw him out of the country on, because the way the case law comes down, that involves fraud and dishonesty. It's a crime involving moral turpitude. The other stuff is not a crime involving moral turpitude, nor does it constitute an aggravated felony. So although he may get thrown out of the country anyway, he at least has grounds for fighting it. Whereas if he were convicted of one of these other offenses, he's just gone.